Why haven't we got any sound? I wonder why we have no sound. Hello, hello, hello. Any sound? Is there sound? Let me know. It's showing that I've got sound this end. Good, that's the first person that can hear me. Okay, that's good. Let's go then. I was talking a load of rubbish, so I'm told we're good now. So let's get going. I actually haven't read this, so you're gonna get my immediate reaction as I go through it, which is always good. Now, for those that don't know me, I was absent for most of yesterday, and the defendants put in a motion to stay discovery in this action. So this is Floyd's response, which has come within, well, less than 24 hours, I think. So let's go. Yeah, I've been playing with the settings on the mic, so yeah, I did get the rambling out the way. So here we go. So it's a motion, plaintiff's opposition to defendant's motion to stay discovery. I, plaintiff Floyd Wallace, oppose defendant's motion to stay discovery. This motion is made and based on the attached memorandum of points and authorities, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of the hearing. Memorandum of points and authorities. A. Circuit's tests for motions to stay discovery. Courts in this district have adopted a two-part test to determine whether to stay discovery pending resolution of a dispositive motion. I'm just noticing something on that citation. Yeah, my mouse is coming through, I think. There is Pittsburgh, Pennsylvania. Courts in this district, we're quoting a Pittsburgh, Pennsylvania case. Now, I am not an expert on US geography, but I think I know that Pittsburgh is quite a way away from Nevada. Anyhow, let's get going. First, the pending motion must be potentially dispositive of the entire case, or at least dispositive on the issue at which discovery is directed. And is that the same citation? Yeah, it's the same citation. So, for some reason, we're citing, I don't know. MERB can deal with that. Second, the court must determine whether the pending dispositive motion can be decided absent discovery. Looks like this is another citation from that case, which would appear to be outside the circuit. If the court answers these two questions in the alternative, a protective order may issue. I got that totally wrong. If the court answers these two questions in the affirmative, a protective order may issue. However, if either prong of this test is not established, discovery proceeds. In applying this two-factor test, the court deciding the motion to stay must take a preliminary peek at the merits of the pending dispositive motion to assess whether a stay is warranted. Now, what's this other case? I can't tell what district those two are in. But I'll let a lawyer look them up, and probably they'll be in the wrong district. B. Oh, we moved across there. Sorry about that. B. Court cannot assess the merits. In this case, as defendant's motion to dismiss are not fully briefed, the court cannot assess the merits of the motion That was it. That's B. B. Courts cannot assess the merits. In this case, as defendant's motion to dismiss are not fully briefed, the court cannot assess the merits of the motion. Nothing. No explanation. Right. Okay. C. Not all claims fail. Despite the defendant's continuous... here we go. Despite the defendant's continuous misstatement of the facts, in this case, and continuous fanciful legal conclusions, well, they are lawyers. I'm not sure News Now Omaha even got his GED, so... The facts show, and the defendants admit to, 1. Detaining me without any reasonable, articulable suspicion of a crime. I have read their motion, and I think they're quite detailed on why there was reasonable articulation of a crime. 2, using excessive force by pointing a gun at me. Again, they dealt with that. Never asking me for my identity. Brackets, they never assert that they asked, only that I refused, which I did not and could not have done if they never asked. 4, arresting me without probable cause for filming through offence from the public while I was exercising my First Amendment rights to record police interactions, which is a clearly established right, and that's an old case that we should all be familiar with, Fordyce v. Seattle. Right. Arresting me for a misdemeanor offence, which they could have simply cited me for. But they didn't cite you. They don't have to cite you. And which their arrest policy says to not arrest for. Yeah, but that doesn't mean that they can't arrest you. Only to not have any charges brought, resulting in my being arrested simply as a punishment for recording the police chilling my civil rights. I think charges were brought, but they weren't proceeded with. See also this court's own decision, and that is a Nevada case. Defendant's video submission at timestamp just before 1 minute show the officer's gun pointed directly at me. The video also clearly shows the officers asking me for my identification. Oh my giddy aunt. The video... The video also clearly shows the officers asking me for my identification, not my identity. Chili or Floyd or Chili or Floyd. Identification is proof of one's identity according to every dictionary in the world, including the Oxford Language Dictionary. So Floyd has seen every dictionary in the world. The video also shows me providing my identification under threat of arrest, yet I was still arrested. Well, you probably... I've got to highlight that one. Thank you. I like that new toy. Sorry. Moreover, even if some or all of my claims are deficient, the court will assess whether leave to amend should be granted, rendering defendants' motions non-dispositive. 1, 2, 3, 4, 5-syllable word there, I think. Non-dispositive. There's a citation. Deny motion to stay discovery pending resolution of motion to dismiss. And there's the discovery from another circuit. And there's something in this court's jurisdiction. D. Expense of discovery doesn't warrant a stay. Defendants argue that they don't want discovery to proceed because of expense. The fact that discovery may involve some inconvenience and expense doesn't automatically warrant a stay of discovery. Citation. The respondent's party is expected to carry the burden of responding to discovery requests. Citation. I've just read the next bit and I'm struggling because I think if I read it, I'm going to... E. I plagiarised this motion. I plagiarised the majority of this motion. I can't even... And what point is he is he making there? Oh, I'm loving these comments. I'm loving that I can highlight them as well. I'm going to get a great ego boost from this. As a result, discovery must go on regardless of whether a party has moved for a stay. I have emailed defendant's counsel asking when we can schedule a conference. They have not responded. Conclusion. Accordingly, plaintiffs respectfully request this court, in the interest of not delaying this case and preventing the defendants from withholding evidence. Respectfully submitted. I've got to be careful because someone does like a privacy strike on these motions. I was careful not to show the phone number at the top or Floyd's email at the top. Yes, he's admitted guilt of plagiarism, but I think that is quite common in the legal profession. I believe they take one another's good motions and just replicate huge parts of them. So I don't think that's anything wrong with that, but I'm not sure many state that I have plagiarized this motion. Right, let me just see how many of you there are watching here. What the fuck am I hearing? You're hearing Floyd's motion to not stay against a stay of discovery. This is Floyd who wants to delay things to get a lawyer, but now he doesn't want to delay things as regards discovery. Now, as I said, I don't know how many there are of you, and why can't I bring this up? There it is. Oh, we got a few concurrent viewers. Shall I go through yesterday's motion, which was their request to stay discovery? I mean, it's obviously not going to have the laughs that Floyd's, Chili's, Floyd's, who knows? Who knows writing these motions? It might be chat GBT. I don't know. Shall I go through the motion that he's responding to here? Okay, I'll continue. I probably expect a drop-off of viewers because some will have... I'm going to highlight these and say hi. Wait until discovery. Yeah, exactly. I would have thought, discovery, he's got more to fear than his opponents on this. Have I got that all in screen? Right. Let's switch windows to the... Oh, I don't like that black bit at the top. Can I get rid of it? That's better. Okay, so this was the motion that Floyd has responded to. It's the defendant's motion to stay discovery. I'm not going to go through the preamble. It was yesterday. We don't need to go through the event because we all know what the event was. We know that the defendant officers arrested Wallace and took him to jail. The district attorney... Oh, keep on... Blooming mouse. The district attorney did not pursue the charges. And on July 17, LVMPD filed its motion to dismiss, and on September 1, the individual defendant officers filed their motion to dismiss. Both motions established that Wallace's claims are untenable as a matter of law, as the officers had probable cause to arrest Wallace. Wallace doesn't think so, but probably most other people think that they probably did. In addition, the individual officers argue they are protected by qualified immunity. The LVMPD defendants now request that this court stay the litigation pending resolution of the LVMPD's defendants' motions to dismiss. The purpose of the requested stay is to prevent the parties from incurring unnecessary fees and costs, as well as the other burdens of litigation. Qualified immunity is immunity from suit, not damages, and courts should decide the issue at the earliest stage in the litigation. Citation. Therefore, a stay of discovery is appropriate until the LVMPD defendants' motions are ruled upon to protect the individual officers from the burdens of litigation. Further, the stay will protect Wallace from incurring unnecessary fees and costs. Background. Right, that's just the incident. That's just the incident. I'm not going to go through the incident again. Okay. I'm not going to go through the courses of action. That's just wasting everyone's time. Right. Down to 3 legal standards. Obviously, you can go back and look at those bits that I've scrolled through there if you want to. Legal standards. A district court has discretionary power to stay proceedings in its own court. Citations. Staying proceedings pending a decision regarding a motion to dismiss. Further, courts may restrict discovery to protect a party from annoyance, harassment, or undue burden or expense. And that's from Federal Rules of Civil Procedure. The rules shall be construed and administered to secure the just, speedy, and inexpensive determination of every action. Because courts have significant discretion to manage their dockets and control discovery, an order staying discovery pending resolution of a motion to dismiss will not be overturned absent a clear abuse of discretion. Citation. Courts in this district, and I suspect that this lawyer knows what courts in this district do, courts in this district have formulated 3 requirements in determining whether to stay discovery pending resolution of a potentially dispositive motion. Motions to stay may be granted when 1. The pending motion is potentially dispositive. 2. The potentially dispositive motion can be decided without additional discovery. And 3. The court has taken a preliminary peek at the merits of the potentially dispositive motion and is convinced that the plaintiff will be unable to state a claim for relief. 4. Legal argument. A. Potentially dispositive. LVMPD's motion to dismiss makes 3 arguments. First, it argues that Wallace's complaint fails to state a claim because the admitted facts fail to state a claim under both federal and state law. The motion also argues that even if the complaint states a constitutional violation, Wallace failed to include any facts suggesting a Monell violation. Third, the motion argues with respect to the state law claims that even if the complaint states a claim for relief, the officers are entitled to discretionary immunity pursuant to NRS 41.032. If LVMPD's motion is granted, all of Wallace's claims against it will be dismissed. I've just seen something. Didn't Chile get DMA arrested? Yeah, he probably did. He didn't help that situation. That's a long time ago now. The individual officer's motion to dismiss mirrors LVMPD's motion's arguments, except on the Monell claim. In addition, the individual officers raised the issue of qualified immunity, arguing that even if Wallace had pled a constitutional violation, the officers are entitled to qualified immunity because no clearly established law exists prohibiting their conduct in this case. If the officer's motion is granted, all of Wallace's claims against them will be dismissed. B. Need for additional discovery. There is no additional discovery that could change the outcome of this case. First, Wallace's complaint sets forth sufficient facts for the court to dismiss all claims. Second, in a recent filing, Wallace submitted his own videos of the subject event and requested the court take judicial notice of the videos. the officers were able to incorporate Wallace's videos into their motions to dismiss. Thus, the court can review Wallace's allegations and his own videos to determine whether or not his rights were violated. The videos established that reasonable suspicion existed to detain Wallace, that obstructed the officer's investigation, and that all of the force used was reasonable as a matter of law. Citation. Citation. Where did I get? When video evidence exists, courts should rely on the video evidence if it blatantly contradicts the non-moving party's version of events. C. Preliminary peek. The final requirement is for this court to conduct a preliminary peek of the merits of the motions to dismiss to determine the likelihood that the claims will be dismissed. Citation. The court should stay the case when it is convinced that the plaintiff will be unable to state a claim. Wallace's federal law claims against LVMPD. LVMPD's motion will certainly be granted. Wallace's only federal law claim against LVMPD is a Monell claim. A Monell claim is a claim for recovery against a local municipality where a government entity could be held liable only when a constitutional deprivation arises from a governmental custom. Citation of Monell. In other words, when a municipal policy is the cause of the unconstitutional actions taken by the municipal employees, the municipality itself will be liable for those actions. Liability only exists where the unconstitutional action implements or executes a policy statement, ordinance, regulation, or decision officially adopted and promulgated by municipal officers, or where the constitutional deprivation is visited pursuant to governmental custom, even though such a custom has not received formal approval. The court defined custom as persistent and widespread discriminatory practices by state officials. Citation. Furthermore, the doctrine of respondeat superior does not apply to 42 U.S.C. 1983 claims against municipalities. Further citations. In other words, municipal liability would not be established simply by showing that a municipal employee committed a constitutional tort during the scope of his or her employment. In order for a municipality to be liable, a plaintiff must establish that the wrongful act was somehow caused by the municipality. An affirmative link between the policy or custom and the particular constitutional violation alleged must be shown. Citation. Moreover, the alleged policy or custom must be the moving force behind the constitutional violation in order to establish liability under Section 1983. Citation. Causation must be specific to the violation alleged, meaning that merely providing an unconstitutional policy, practice, or custom will not in and of itself establish liability, unless the specific injury alleged relates to the specific unconstitutional policy proved. Citation. Once each of these elements are met, a plaintiff must also prove that the unconstitutional policy that caused him injury was the result of something more than mere negligence on behalf of the municipality and was instead the result of deliberate indifference, which is a state of mind that requires a heightened level of culpability, even more so than mere indifference. Proof of a single incident is insufficient to establish a widespread custom or policy. To plead a proper Monell claim against LVMPD, Wallace must 1. Identify the challenged policy or custom, 2. Explain how the policy or custom is deficient, 3. Explain how the policy or custom caused the plaintiff harm, and 4. Demonstrate how the policy or custom amounted to deliberate indifference by showing how the deficiency involved was obvious and the constitutional injury was likely to occur. Citation. Post-Iqbal, a plaintiff cannot solely rely on conclusionary factual allegations. That's what Floyd appear to want to do. Instead, a plaintiff must allege facts which, if true, show the defendant actually had a constitutionally impermissible policy, practice, or custom. Citation. An actionable policy or custom is demonstrated by 1. An express policy that, when enforced, causes a constitutional deprivation. 2. A widespread practice, although not authorised by written law or express municipal policy, is so permanent and well settled to constitute a custom or usage with the force of law. Or 3. A constitutional injury caused by a person with final policy-making authority. Citations. LVMPD's motion points out that Wallace did not plead any facts suggesting a constitutional violation, or more importantly, that LVMPD even has an unconstitutional policy, custom or practice that was the moving force behind any alleged violations. Wallace's opposition to LVMPD's motion ignores LVMPD's arguments and, via silence, concedes that he has no facts supporting his Monell claim. Wallace's federal law claims against the individual officers. Wallace's federal law claims against the defendant officers can be grouped into the false arrest-based claims and excessive force-based claims. The false arrest-based claims include his false arrest claim, first cause of action, equal protection claim, second cause of action, First Amendment retaliation, third cause of action, and Section 1981 discrimination, fifth cause of action. As set forth in officer's motion, all of these claims require that Wallace provide facts suggesting that his arrest lacked probable cause. A claim for false arrest is cognizable pursuant to Section 1983 as a violation of the Fourth Amendment when the arrest was without probable cause or other justification. Citation. To determine whether an officer has probable cause at the time of an arrest, a court considers whether at that moment the facts and circumstances within the officer's knowledge were sufficient to warrant a prudent man in believing that the petitioner had committed or was committing an offence. Probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of such activity, and is not a high bar. Citation. In Nevada, probable cause can be based on slight evidence. Citation. Finding probable cause existed even though witnesses' identification was in direct conflict with that of another witness. Because the probable cause standard is objective, probable cause supports an arrest so long as the arresting officers had probable cause to arrest for any criminal offence, regardless of their stated reason for the arrest. Citation. As set forth in the defendant officer's motion, the officers had probable cause to arrest Wallace for attempted trespass under NRS 207.200(1) or obstruction under NRS 197.190. Further, as established by Wallace's video, the officers learned he had a warrant out for his arrest in a different jurisdiction. Thus, it is certain the court will dismiss Wallace's false arrest-based claims. There's quite a discussion there on probable cause. If you've not seen the videos of Zane Kane getting arrested for entering his girlfriend's house when his girlfriend had no legal right to enter herself, and she couldn't give that right to him, and he was arrested, that is a good example of where probable cause existed. And I'd love to see Zane Kane's claim. I've even forgotten his name at the moment. What's this? This is a question. Hey Frog, what does the PK stand for? PK is the small group that enables this to be brought to you. Without PK, most of my output would not be possible. The PK people know who they are, and I thank them very much. The excessive force-based claims include Wallace's first, sixth and seventh causes of action. Prior to Wallace submitting and requesting the court take judicial notice of his own videos, the excessive force-based claims are a close cause. There's another one here. Sorry. Any person that would take legal advice from Chile should find an attorney who has gone to law school and passed the bar. Exactly. Wallace claims the officers drew and pointed their firearms at him. The officers acknowledge that the drawing of a weapon may be unreasonable if the police officer terrorizes a civilian by brandishing a cocked gun in front of that civilian's face while investigating a minor crime against a citizen. Citation. Pointing guns at persons who are compliant and present no danger is unreasonable. Wallace's video defeats this claim as it clearly shows one officer pulled his weapon for a few seconds as he approached Wallace. However, he never pointed the firearm and hoisted it immediately when Wallace finally complied with orders. Thus, with the assistance of Wallace's own videos, the excessive force-based claims will fail. Finally, Wallace's Section 1981 claim is untenable as a matter of law. And there's a citation. Wallace's state law claims, for the same reasons that Wallace's federal law claims fail, his state law claims also fail. In addition, the defendant's officers have discretionary immunity from his false arrest-based claims as the actions constitute discretionary functions. Citations. Concluding that no civil liability attached to a state trooper's decision to arrest a driver for allegedly refusing to sign a traffic ticket because the decision to do so was discretionary decision requiring personal deliberation and judgment and thus entitled to immunity under NRS 41.032 brackets 2. And citation. The decision of whether to make an arrest is largely discretionary. Something these idiots don't get. It's discretionary. Wallace never opposed this argument in his opposition to LVMPD's motion to dismiss. That's because Wallace or the people who wrote the motions for him are idiots. D. A stay of discovery is appropriate when the issue of qualified immunity is raised. The defendant officer's motion raises the defence of qualified immunity on all federal law claims. The Supreme Court has made it abundantly clear that a district court should stay discovery until the threshold question of qualified immunity is settled. Citations. This is because qualified immunity is an entitlement not to stand trial or face the other burdens of litigation. Citation. The privilege is an immunity from suit rather than a mere defence to liability. Qualified immunity is meant to protect public officials from the broad-ranging discovery that can be peculiarly disruptive of effective government. Citation. To minimise the costs incurred by an immune defendant, the Supreme Court has emphasised that a court must resolve qualified immunity questions at the earliest possible stage in litigation. Citations. Accordingly, where defendants have filed dispositive motions based on qualified immunity, a court should stay discovery until the threshold question is settled. Citation. If the defendant does plead qualified immunity, the court should resolve that threshold question before permitting discovery. Courts routinely stay discovery in cases where the issue of qualified immunity is raised early in litigation. Citations. Here, there is good cause for a stay of discovery pending the resolution of the defendant officer's motion. The complaint's admissions are sufficient to allow this court to determine whether dismissal as a matter of law is appropriate at this early stage. In doing so, the court will be complying with the Supreme Court's mandate that qualified immunity and these issues be resolved at the earliest stage in the litigation as possible. And that's Morales. E. A stay will improve the just, speedy and inexpensive resolution of this matter. Rule 1 of the Federal Rule of Civil Procedures states that rules should be construed, administered and employed by the court and the parties to secure the just and speedy and inexpensive determination of every action and proceeding. FRCP 1. A district court enjoys wide discretion in controlling the scope and extent of discovery, and it is not an abuse of that discretion to stay discovery until the question of a defendant's immunity can be resolved on summary judgment. Citation. Staying discovery pending resolution of the LVMPD defendant's motions will save significant time, money and resources. And actually, in my opinion, not just for the defendants, but for the plaintiff as well. I mean, can you imagine him coping with discovery? Therefore, the conclusion was, because it's certain that LVMPD's motion and the defendant's officer's motions will be granted in their entirety, the LVMPD defendants request that this court stay discovery pending their resolutions. And that was yesterday's motion, to which Floyd has responded. And as we saw, and I'm going to bring that window back up, get rid of that one, and we should be back on Floyd's one. At E, I plagiarized the majority of this motion. Thank you, Delete Laws, as a constitutional law scholar, for confirming that you did not write the motion. Right, so that's yesterday's motions, today's response, other things that have happened when I've not been able to do a video at all was obviously Chili's hearing yesterday. It was a very quick continuation because his attorney needs time to look at discovery and possibly raise some further discovery issues. The judge wanted it to take place, I believe, on the 13th of December. Chili said he'd be away, so it was brought forward to the 6th of December. It wasn't delayed, as some have questioned. Love your laugh when reading Chili lawyers. I ought to highlight these up. Yeah, there we go. I specifically like reading them without having read them, because you come to a point you're just thinking, what? Surely not. Surely he hasn't said it. But I think Chili has this alternative reality. He lives in an alternative reality, because what he sees isn't what most people see. He interprets things totally. He's got this view of how things should be, and everything's interpreted in that way, as opposed to reality. He can't distinguish between what's real and what isn't real, even when video evidence shows that he's wrong. I'm not sure that Chili will be in jail for Christmas. It's only a misdemeanor. Chances are he'll get a fine. As Chili said, he wanted to go out of the country, and the judge brought it forward. I don't think the judge was unhappy with Chili yesterday. Do I hear Chili? I hear more Chili's voice than I do Floyd's, definitely. Thanks, Alex, for making sure that... Oh, we went wrong there. There we go. Thanks, Alex, for making sure that we didn't get any spamming in the chat. I haven't seen anything myself, so... no one really wants anyone to go to prison. However, in order to protect the innocent, to get Chili away from doing some of his activities. What's Bruce say here? Does anyone think that Floyd has noticed that when Chili went to court a day or two ago, he brought Yeah, Chili did actually bring an actual real attorney who's on a fixed fee, as far as I can tell, Bruce. So it'll be interesting how long it will be until that attorney has used all his hours and starts getting annoyed with Chili. Yeah, I think this is probably right. Someone else is involved in the writing of the legal pleadings. And then you get Chili's rants on it. I'm not going back in chat. I'm just going forward. I'm not going to go. And once again, I'm not going to go through everyone who's in here, but thank you for joining me. It's always appreciated, especially if you've stayed with me this long for the second motion, because it was by no means as fun as the first motion that I read. I'm curious about the elusive PK Discord server. Doesn't exist. There's no elusive PK Discord server. All communications are via, what was I going to say? Encrypted communications. Right, I'm going to leave you. Thanks for joining me. Thanks, everyone. I'll catch you later. Maybe we'll get an arrest this week. I really am missing an arrest or someone new to find. We need some action. Come on, you auditors. You need to get out there and get arrested. All those donos went to Deborah's, Biden's and Ginny's briefcase. What happened to Deborah? His successes. Yeah, I will say bye. I could keep rambling, but I don't want to be a streamer that does that. I really want to just read these out, but I thought, no, I've worked out how to get a specific chat up on my screen. Do you like that? I hope you like that. It does enable me to sort of do a bit more interaction and actually show the chat that I'm interacting with. So thank you. I think I'll use that again. Cheers. Hopefully we'll have an arrest and that will be my next video. Thanks for coming in.